Today we shall discuss these two important news that have been doing the rounds since the past more than a week now, and we'll see how these two are ultimately related to Article 14 of the Constitution. So let's start. First, we'll start by understanding the case with the Chief Minister of Karnataka, Mr. Siddaramaiah. Let us see what the complaint against him is. The complaint. So, three anti-corruption activists, they have alleged that in 2021, the wife of the sitting chief minister has received 14 housing plots from MUDA. MUDA is Mysore Urban Development Authority. And the activists allege that because of this transaction, the state has lost rupees 55.80 crore. Now, why have these housing plots been assigned to Miss Parvati? The wife of the chief minister is named Parvati. Why has she been allotted these lands? Because in 2013, some 3.16 acres of land belonging to her was illegally acquired by MUDA. Soon after such allegations surfaced, a whole row of political activities started. In August 1, 2024, the Council of Ministers, Karnataka's Council of Ministers, they passed a resolution, all right. They passed a resolution strongly advising the governor to withdraw the complaints of the activists. But the governor gave sanction but against this resolution, the governor gave sanction to the police to start an investigation against the CM under Prevention of Corruption Act 1988 and Bharatiya Nyaya Sanhita 2023, PCA 1988 and BNS 2023. This happens in August 16, 2024. The governor acts against the aid and advice of the Council of Ministers of Karnataka and gives sanction to the police to start an investigation against the Karnataka Chief Minister. So, what are the questions that arise as a result of this? First, why did the governor give such a sanction? Second, what did the CM or how did the CM challenge such a sanction in the court? And finally, what did the High Court say? What did the Karnataka High Court say? Let's see. In the order that was passed by the governor, he has stated two reasons for giving such a sanction to the police. One, that it was an extraordinary situation. How is that so? Let's understand. So we have seen that the Council of Ministers, the Karnataka Council of Ministers, has given an advice to the governor to withdraw the allegations. But the governor said that the Council of Ministers did not act in a bona fide manner in this case. This was because this Council of Ministers is appointed by the CM. So we cannot completely trust that the resolution passed by the Council of Ministers will be free of bias. Secondly, the second reason cited in the order was that the resolution that was passed by the Council of Ministers, it ignored a number of key information about the transaction. So these were the two reasons that were cited by the governor while he gave sanction to the police. Now let's come to the second part. On what grounds did the Chief Minister challenge the sanction in the Karnataka High Court? The first ground was that whether a private person can file a complaint against a public official under Section 17A of the PCA, which is the Prevention of Corruption Act. This is the section under which a case was registered or a complaint was filed against Siddaramaiah. So this was the first challenge made by the CM. The second was that the sanction is invalid since Siddaramaiah was not discharging any official functions at the time of the land acquisition. He was an MLA but in the opposition. This was the second ground on which the sanction was challenged, saying that when the transaction happened in 2021, he was not in power. He was in the opposition of the State Assembly. The third ground was that the governor ignored the advice of the Council of Ministers, and this was in violation of Article 163 of the Constitution, which says that the governor is bound by the aid and advice of the Council of Ministers. We clearly saw in the early part of this video that the governor has clearly acted against the advice of the resolution passed by the Council of Ministers. So these were the three grounds under which the sanction granted by the governor was challenged by the CM in the Karnataka High Court. Let's see what the High Court has responded in case of each of these three grounds. The first ground was that whether the sanction can be given when the complaint is made by a private person. See, in the Section 17A of PCA, any enforcement, the police for example, requires, if the police has to investigate any public official for activities done within the capacity of his office, he needs prior sanction of that authority which has the power to dismiss that public official. In case of the Chief Minister of a state, because the governor is the appointing authority, so it is the governor who can dismiss the CM. Hence, if the police has to start an investigation against the CM, it needs the sanction of the governor. This is what 17A of the PCA mandates. Why is such a sanction essential? It is in order to protect the public officials from frivolous cases. Now the court said that if private individuals are not allowed to file complaints under Section 17A of PCA, then that will leave the private individuals with only one other option, that is to invoke the Code of Criminal Procedure. And in the Code of Criminal Procedure, such protection of a prior sanction, such protection of requirement of a prior sanction is not available, and hence the public official can't be protected against frivolous cases if people resort to this provision, if people resort to the Code of Criminal Procedure to file complaints against them. Hence, the court said that private people must be allowed to file complaints against public officials under PCA so that the facility of requiring a prior sanction can be upheld for the public officials. Next, coming to the next ground. Now we have to see how did the court nullify the second ground on which the sanction was challenged. See, the court noted that the alleged scam pertains to a series of transactions that was related to the acquiring of those 3.16 acres of land in Mysore. Let's see what those transactions were. Firstly, when the Chief Minister was a member of the ruling party, his brother-in-law acquired the land in 2004 and got permission to convert it from agriculture to residential land. This was the first incident. Second, let's understand it in a better way. So, in 2015, the wife of the Chief Minister, Parvati is her name, she had filed an application. With the government. This was in 2015. The present Chief Minister was in power. So she had filed an application saying that the compensation for the land acquired by the Mysore Urban Development Company, the compensation should be increased. And after her application itself, such a provision was brought about wherein the compensation for land acquisition was increased. And according to that application, she was supposed to receive in compensation of 3.16 acres, she was supposed to receive 4,800 square feet of land, but she received a total of, or rather a whooping, 38,284 square feet of land, worth rupees 55.8 crore. And this is what the activists have alleged, that there is potentially a scam here. Another incident was that their son was an ex officio member of the MUDA when compensation of 14 sites of Mysore city for Parvati was finalized in 2017. Lastly, the court also found that significant action from the state appeared to coincide with Siddaramaia's stint as MLA, Deputy Chief Minister and Chief Minister. All these are things that the court has mentioned in its proceedings. So because of these reasons, the second ground of challenge of the sanction, which is the fact that he was not in power when the transaction happened, that second ground also gets nullified. Now let's see the third and the last ground. The third ground on which the sanction was challenged was that the governor has acted against Article 163 of the Constitution. So what did the court say in this regard? The court said if there is a real likelihood of bias from the state government, say this is the state government headed by the CM and this is his Council of Ministers. If there is a real likelihood that the Council of Ministers, which is led by the CM, have acted out of a bias, then in such cases the governor can take decisions out of his discretion. So I think this leads to an important MCQ, that if you are asked is Article 163 binding upon the governor, so not under all cases. Okay, Article 163 is not binding on the governor under all cases if there is a real likelihood of bias. A real likelihood of bias from the state government, then the governor can act independently, right? The Chief Justice, the Justice who was overhearing the matter cited a Supreme Court ruling in Madhya Pradesh Police Establishment versus State of Madhya Pradesh 2004, wherein the court held that the governor could provide sanction if the material on record shows a prima facie case against the public official. Okay, since in this case also we can't be 100% sure that the Council of Ministers has acted in a manner which is completely free from bias, so the governor can't be expected to accept the aid and advice of the Council of Ministers in this case. So these are the three explanations given by the court while discarding the grounds on which the CM had challenged the sanction in the Karnataka High Court. Now let us go to this brings us to an end of this particular topic. This particular topic related to the case of the Karnataka Chief Minister. Let's see why there has been an FIR against the Finance Minister Nirmala Sitharaman. So there is a compliant. His name is Adarsh Iyer. Adarsh Iyer, he is the co-president of the Jan Adhikara Sangharsha Parishast. I hope I'm pronouncing it correctly, but this is the name of his organization. He is the co-president of this organization and he has filed a complaint against the finance minister, the enforcement directorate and few other members of the present ruling dispensation. The complaint alleges that the allegation is that these people, they have done criminal conspiracy. Just give me. Yeah, they have done criminal conspiracy, extortion, and there are charges of compelling leveled against these individuals. They have committed these actions against both individuals as well as companies through electoral bonds. Okay, through electoral bonds in the favor of the BJP. This is the allegation. The complaint claims that the finance minister has used the enforcement directorate to conduct raids, seizures and arrest on corporates and thereby extort money out of them. Now a special court has taken cognizance, a special court which deals with criminal cases related to elected MPs, MLAs in Karnataka has taken cognizance of this complaint and it has passed orders. And based on these orders, an FIR was registered against the finance minister. But the High Court of Karnataka, the High Court has given stay orders for stopping the further proceedings on the FIR, and the next hearing date will be on October 22nd. So we shall see what course this FIR takes. But for us, what we have to understand here is also one more thing that you might as well take note of, is that the allegations have been leveled under the IPC. Criminal conspiracy comes under IPC section 120B. IPC extortion under IPC 384, and because more than one people are involved in this, so this is IPC 34, which is for acts by multiple individuals with a shared intent. Because this information was also available in the article, so I have just included here, but I don't think you should spend too much time remembering all these. It might not have a very good cost benefit ratio. Nevertheless, the important thing that we need to note here for our exam is, see, we should stay away from the politics of these news articles because that won't be asked. But we have to see that in both the cases, what is that one article of the Constitution that both these cases are pointing towards? It is Article 14 of the Constitution, which says that the state shall not deny to any person equality before the law or the equal protection of the laws within the territory of India. Now, 2 points are important to be noted out here. There are 2 important phrases in this sentence: equality before law, okay, and equal protection of laws. These two are 2 separate concepts in themselves. Equality before law is a British concept, and it is a negative concept. Why negative? We will see. Equality before law means that no one is above the law. Secondly, it means equal subjection of all persons to the ordinary law administered by the ordinary courts. It means that the ordinary courts of the country, whatever laws they administer, these laws will apply equally to every single individual of this country, no matter who you are. Every single individual of this country will be subjected to these laws. And third, no privilege will be conferred in favor of any person. No privilege will be conferred in favor of any person. So these 3 explain the concept of equality before law. Now, in this case, because no one is above the law, that is why it does not matter whether you are the finance minister of the country, whether you are the chief minister of a state, you will be subjected to whatever the law of this country is. Whatever the law of the country is, you will be subjected to it. And you will also not have any privilege in that regard. You will have to attend to the calling of the judicial system. So this is what we were supposed to understand from this discussion. I hope you have understood what all we were supposed to have learned from these 2 incidents and what all is important for our exam point of view. Thank you for watching. If you have reached this part of the video, then thanks a lot for watching till here. Also, we noticed that more than 80% of you who watch the video do not subscribe. Please subscribe to us because
सपने देखना अच्छी बात है, लेकिन सपने को लेकर के बैठे रहना और सपनों के लिए सोते रहना, ये तो सही नहीं है। सपनों से आगे बढ़कर अपने सपनों को पाने का संघर्ष बहुत महत्वपूर्ण है। शुभ रात्रि।